himself. But let me have some peace. I think he wants to destroy my train of thought. So the point I was saying, I can be happy, or God can defend himself what he told me. But my Lord, I'm saying, at least for my community, that issue arises. Does any of you have a problem with any of these wazes who will decide the issue? My Lord, if the issue arose that a party says, I don't want that Mzee to be there, or that other one, invariably, and this is communal justice, that person would pull out and get a Mzee, another Mzee, that everybody feels comfortable with. So that, my Lord, and I've appeared with you, I respect all of you absolutely. The petitioners are saying the circumstances of this matter is that we are unable to enjoy that confidence. My Lord, when the petitioners were speaking about what they said they feel, like is a three-judge bench, one in which they expect fair and square justice. That was a terminology in the case of Gerongori that we have attached on our submission. That from the word go, a party appearing before the judges should be able to feel that we have a reasonable chances of success between those judges, but more importantly, that none of the judges is connected to the cause, one, to the cause, or to the individual in which you are in dispute with. My Lord, why is that important? That, my Lord, is important because since Saturday of this week, in fact up to yesterday, but the petitioner says they have been treated to a situation, and a lot of those information people have sent it to my phones because they have seen me on television. We have such a scenario that repeatedly they keep saying we are going to have what is it called? We are going to have a swearing in as soon as these three judges lift those particular orders. But that cannot create confidence because assuming it is not this case, every party, and we have very many cases here, if somebody you are drinking in a bar says, no, you are going to lose that case before the persons we appear in the court. That, my Lord, is a party. Parties are not lawyers, are not supposed to be sophisticated. That party will be left certainly with a huge, huge problem as to whether actual justice is possible. And it might actually be, my Lord, that whenever else is dealt, the petitioners will win this case. As we expect, we shall win if the petition is heard. But Lord, if that is the case, and that may actually be the case before you. But my Lord, the scenario that is backed and that is prevented by the law is a scenario where the parties lose. Because they will say, well, you have Ahmed Nasir told us, Oscar Sufi told us, Kariket told us, and all these individuals who are saying it was called drama. We are here for entertainment. But Lord, if judges are supposed to be treated to entertainment, and those judges are supposed to stop that entertainment, but Lord, there is a problem on the face of it. There is a notice of appeal that we have filed, and it is part of a supplementary affidavit. In this notice of appeal, Your Lordship, we have pointed the issue, and we have said one of the other issues of concern is that the judgment of this court that dealt with these other issues, that judgment, the contents of that, amounted to preempting and answering the application that I'm arguing before the court. Because those issues we are submitting did not come from the respondents, but these applications having been filed, we are arguing these applications. After, in a previous ruling of yesterday, we have effectively been responded by the court itself. The petitioner says that they are absolutely uncomfortable with that, and they cannot be able to say that if we have reached a situation whereby judges are answering our case in advance, it is absolutely bad and beyond repair. But the second last issue that I want to say is this. The issues, my Lord, is, and we expressed that concern yesterday, we were not sure whether we would even file a notice of appeal as counsel. But you are told you cannot file this one because it is the issue, as far as we are concerned, we were not treated fairly. We were accused, we are playing to the gallery. As a result of the accusations and indictment that we are playing to the gallery, what effectively ended up being glossed over is the question of is a question of our own submissions. And my Lord, the basis, and therefore the accusation, and we are saying we were not treated in a temperate and judicious manner. The petitioners and their advocates. Then, my Lord, we go to the deciding for purposes of yesterday, the core issue. My Lord, the core issue in our petitions, a number of them when it comes, would be the question, does the IEBC have the power to have authorized the president to say that he did it? I'm saying it is in our petition. I'm saying one of the issues that will be coming in for determination.
My lords, I think it is important to just help my learned friend. We are not having the substantive application. It's a recusal. Let him stick to the issues.
Let him hear the issue and the answers.
But just do the right thing.
My Lord, the point I was making is this. One of the questions, I want to tie it with 165. And the question is this. The question that would be arising is whether the IEBC without commissioners could have declared Honorable Kindiki to be suitable for this nomination in the letter they did to the President. My Lord, that particular issue is significant because the petitioners are saying that this court, having effectively read Article 165(4) in a manner that amounts to amendment of Article 165(4), they perceive the real danger that when a more important question arises, the same logic would be applied against them. And they are saying, this being a very serious legal issues, the bench cannot be said that for purposes of the issues actually in contention, that the people can be oblivious of such an issue. I need like 2 or 3 minutes. My Lord, having said that, therefore, it is our submissions. And as our Honorable Muta said, nobody extracts any joy to raise this kind of an applications because judges are legal points. But my Lord, the point that we also want to add for purposes of this application, and this is contained, I believe, in the affidavit of my clients, is of course to point out to the issue. But the Honorable the Deputy President, regarding Gachagua, by a letter dated 23rd of October 2024, did file a complaint against all your lordships. And this complaint was acknowledged by the Judicial Service Commission that it has been received. Then there is the issue that required disclosure. According to the petitioners, I wasn't even aware of this, I saw it today. According to the petitioners, is that there is a very close relationship between one of your lordships, the Honorable Judge Murima, and the Speaker of the National Assembly, who is the Speaker of the Senate, who is a member of here. That close relationship, according to the petitioners, is one that ought to have been disclosed so that parties could be able to make up their mind that are you comfortable? And we do that every day. I've actually not proceeded in a number of matters for some of the judges who are my classmates saying, keep your this, you are close to a friend. Are you comfortable? That question ought to have been raised. That issue was not raised, and as a result of that issues not having been raised, and now having come to public notice, the petitioners are of the view that it would not be proper to be able to proceed in this matter. My Lord, in conclusion, what I would like
before my learned friend concludes, I want you to be added another minute. Could he please, to assist us to respond, set out the nature of that relationship and where it is expounded in the affidavit?
Well, my Lord, I thought that can actually come during the response, as I say.
No. The duty, the burden of establishing facts is on the person pleading the facts. So we want to know that relationship so that we can respond to it.
Yes, my lord. I have no problem whatsoever. There is a written affidavit. My lord, in paragraph 6 of the supplementary affidavit, it reads as follows: whereas I was not aware about the relationship between the Honorable Justice Mrima, who is among the three judges having this matter, and the fourth respondent, that is Hindi, it has been brought to my attention that the Honorable Judge and the fourth respondent, Speaker of the Senate, are very close friends as demonstrated as here under. 1. The respondent attended the wedding ceremony of the judge and they took a photograph with him. In a post on social media, he indicated. I thought I should finish.
Yes.
The position of the land family I have taken in my humble submission was no support to this. We are not here to destroy professions. Disclosing some of the details may not be the right thing to do. I think one should make a reference in a tactical manner, which the Lordship will be able to appreciate of what is going on. I would respectfully say to you that this is an area where we have also to protect the judiciary, the judges, the magistrates, the judicial officers. I'm not very sure that we should have an in-depth account of what really what is concerning.
Thank you, Dr. Kaminwa.
Let me explain that, my lord. There is a new affidavit that has just come online that contains some of these allegations. It wasn't there before, and that's why we sought. Now, you may proceed.
My lord, I think I agree with Dr. Kaminwa that unless, because as I say, the source of any of this information or something that came to my knowledge, that I was sticking to what my learned colleague is talking about, unless there is insistence by my learned colleagues. My lord, I do not see the value of that insistence as for Dr. Kaminwa's position. It is stated in the affidavit. I will not say anything more on that. The respondents can say we can have a rejoinder when the issue arises. My lord, and the problem with these issues of somebody not continuing what they are saying is that you keep forgetting the last point. The last point, my lord, I think that I was making is this. That at the heart of an application for recusal, the authority speaks themselves, the one we have cited, I may not have time to go through them, is these issues that are considered very important. Number one would be whether, on the basis of the accusation and apprehensions set out, would one party feel that their rights to fair trial before an independent, impartial, and fair tribunal be upheld? The petitioners on that score are saying their rights under Article 50 to fair hearing, which is absolute, would not be possible in the circumstances of this case. Number two, there is a question of the right to protection of law under our Constitution. That right to protection of law requires that for it to be protected, there must not be any doubt that that protection would be availed if it is deserved in accordance with the law. The petitioners again say they have reasons to believe, as a result of all matters taken into account, that their rights under Article 27 The final issue, it could not really have been final, but I have to finish. My lord, the final issue that is critically important for this issue is the old notion, the old principle that justice must not only be done, but must actually be seen to be done. In the circumstances of this case, it is our submission that apart from the real issues that the petitioners have, whether perceptions, whether substantial issues, the petitioners are saying that, your lordships, they are unable to say that at the start of these proceedings, we were confident that these judges are capable of upholding our constitutional rights and to uphold justice equally between us. Lord, we are most observed. Thank you for letting me conclude substantially on what we set out to do. We are most obliged.
Thank you.
My Lord, before the next speaker goes on, I think there is something we are doing and it is not fair to the court, because my learned friend was challenged by Professor Mugay to tell you what is the specific thing. Then they take the posture, assisted by the senior, that we don't want to go there. You cannot eat your cake. The reason they don't want to go there, my Lord, is because it is frivolous. Now, the misfortune we have is this. The world is watching these proceedings. They said we don't want to go there. And the typical person watching this, there is something very serious about the integrity of the court that they have raised. When as a matter of fact, going by the list he had begun is that the judge attended the wedding. The judge went to a restaurant. In one of the applications, they said the judge went to some law school. Clearly, we are being unfair to the court. We want to paint a picture, hiding that we don't want to go there, so that the world will be left with the impression that there is something terrible about it. My Lord, I think it is Lord Cromwell who said, if you want to paint a picture of me, don't embellish it. Say it once and all. If they have any allegations now that we are broadcasting these proceedings to the world, if they have an allegation of any impropriety against any judge, they can't make the claim for the gallery, then say, we don't want to go there. We submit it.
Whose machine is
There's something wrong somewhere.